Good morning. Today is April 15th, and we are going to talk about the Form 17. And I actually didn't write it down on the agenda, I see, but today we're going to talk about the Form 17, the 17C, and the 17 commercial. These are all seller disclosures. And when we talk about these disclosures, we're going to talk about why we have the forms, who's responsible for filling them out, what happens if they don't fill them out, what needs to be disclosed and what doesn't, delivery timelines, we'll talk about waiving or not waiving these forms, and basically what the law says about what we're required to do. So the first part about this is, why do we have these forms to begin with? Well, the history of how this came to be is about up until the time the form was created, there was no law in place holding sellers accountable for disclosing the material facts about their property. The responsibility remained on the buyers to conduct their own inspections, and the result of this caused many lawsuits. So with the need for this change, the birth of the Seller Disclosure Act came to be, and in the late 1994 timeframe, early 95, it became a statutory Washington law for the sellers to disclose any material facts related to their home that are not readily available for a potential buyer. And since the creation of this form and the law, the buyers are now being held to a higher responsibility to do their own due diligence and discovery when it comes to purchasing their home. So in Washington, what we do is we call that kind of a buyer beware state. The responsibility of discovery is placed on the buyer. So knowing this now, who fills this out? Well, we know that it's sellers, right? There are certain people who are exempt and who are not. So the requirements for anybody who is not exempt to fill out, you can think of it as any living seller. So examples of a living seller would be for sale by owner, corporations, bank-owned trusts, or the heirs of a trust, a power of attorney, attorney in fact, an heir of an estate who has taken that title on as their name, not talking about the estate of such and such. If there is one living seller and one of the sellers is deceased, they are not exempt. A boat slip is considered real property and has to have a disclosure filled out. You need one for residential sales, for land sales, commercial, manufactured homes, both on leased land and not leased land, floating homes, even apartment complexes. Relocation companies are not exempt, and sellers who are not living in the home are not exempt. So anybody who is living, the ownership of the property is a living person or even a living entity, it has to be filled out and delivered to the buyer. Now, exemptions on this would be if it is being transferred by a public offering statement. So certain new construction can have something like that. If it's in foreclosure or a deed in lieu of foreclosure, and I'm not talking once the process is over and done with, I'm talking about in the foreclosure process itself. Any gift transfer that's being transferred to a family member or another member, somebody who is has some sort of relational status. A transfer between domestic partnerships or in a divorce settling, estates, any estate of, because the owner of the property is no longer living. Estate heirs can also be considered this too. And if you have any property that's listed as timberland, and then of course, an exemption would be if any buyer chooses to waive the right to receive this. So we have sellers who are required to fill this out by statutory law in Washington. So what happens if they just don't fill this out? Well, we can't really fill this out for them. We have to have them complete it. So if you have a seller who is unwilling to fill this out because they choose not to, please encourage them to complete it. Tell them all questions must be answered completely. And this doesn't matter if it's yes, no, don't know, or does not apply. Every box must be checked out. Any question with an asterisk has to be explained, and that can be explained in the margin at the end of the Form 17 or on a separate piece of paper attached to this to the Form 17. Explain to them the consequences of not complying. So the law says every buyer who is entitled to receive a disclosure is entitled to receive that. And if they do not, they retain the right to terminate the contract until that happens. So explain to that seller that the buyer does leave an opening for a termination that is completely within their right. Also, explain the rights if they don't deliver the complete form. So if they don't answer all the questions, if they're leaving large sections blank, that is also the same thing as not really delivering. Unless that buyer waives it, that buyer retains the right to terminate the contract because they have not received a complete copy. Record all of your conversations in your firm file or in Brokerment. And if they are continuing to file if they're flat out denying to do this, or they have an incomplete one, then file the incomplete Form 17. So what the law says, all sellers of real property are required to thoroughly disclose any material facts. So unless that is waived, that disclosure has to be given. And when does it have to be given? Well, once you go under contract, the seller has to deliver this within 5 days. We do actually have a lot of people who attach it to the listing itself. But what we need to do is we need to not only make sure that that buyer sees it, but that we have provable delivery, that we have given that to the buyer within the first 5 days. The buyer then, unless they waive this, has a 3-day right of termination if they find something that they don't like about this form. So we do not deliver this form to the lender, and we don't deliver it to escrow. This is only a conversation that is between the seller and the potential buyer. So what you do not need to disclose. Think of material facts about the house that could have an effect on the functionality of it, right? So violent crimes or even non-violent crimes that have occurred on the property don't need to be disclosed. Any ongoing criminal or gang activity, registered sex offenders, future development areas, even if there is a development area right around the block and you know apartment buildings are going to shoot up, you're not required to actually put that on the Form 17. Anything that is political or religious activities in the area do not need to be disclosed. Anything regarding neighboring properties or rumors. Basically, what we want to know is everything that that seller knows as a fact, as a material fact. So now here is the form. This is the seller is going to give basically the details of everything they know. Again, every question must be answered. We do not leave any spaces blank. And instructions for this are actually in the instructions to seller paragraph. It says this in detail that all of the items have to be checked in order to create a complete disclosure. And it does cite the law in line 4. Now, delivery, we need to actually kind of come back to the class last week and talk about what true delivery means. So attaching something to the Northwest MLS as attached docs does not mean that it's been delivered to anybody. We can attach all sorts of things to there, but unless we have a way to prove that we've sent it over and it's been delivered, it is not truly counted as delivery for computation of time and the right to terminate. So you must have a provable way to deliver by emailing to the buyer broker and the buyer broker firm, as well as your firm and the TC. If the client has signed this prior to mutual acceptance, you have proof it's been delivered because you have a signature in place. If you do not have a signature in place at mutual acceptance, then you need to make sure you are providing a provable source of delivery for the Form 17. Now, we need to stress to our sellers that this is a disclosure that they are doing on their own with actual knowledge at the time they deliver this form. This has nothing to do with rumors or what they were told before they purchased it. They are going to be writing it on what they actually know. The first paragraph also bullet points that the buyer has 3 days from the right they receive it to basically get out of this agreement if they find something that they don't like, unless they've waived this. As stressed before, and stress it again and again and again, real estate agents are not going to be part of this disclosure. We are not filling this out for our people. This is strictly between a seller and a buyer. We are being held harmless to anything that is on this disclosure. However, if we read this disclosure over and notice that there is something that we know about the property, we are going to be obligated to share that. It just won't be on this form. This is truly a form by that seller to their buyer. And then, of course, we also want to make sure that nobody is truly just depending on this Form 17. We're giving them the opportunity to do inspections. And in this third paragraph, it just kind of holds us harmless again. That's telling this buyer basically that this should not be solely relied on. You are highly encouraged and advised, which is more than just an encouragement, to hire plumbers, electricians, get home inspections, look at pest inspections, take any action necessary to find out anything you need to know before you go through with purchasing this property. This is the form in its entirety. It's the Form 17. It's not the 17C or the commercial. I just pulled the regular Form 17. And when a buyer or seller look at this form, it can be very overwhelming. And as a seller, it can be very daunting to fill this out. So encourage your sellers to get through this. Let them take their time. In fact, this should be one of the first forms you bring to your seller's attention when you're at a listing appointment, because it may in fact take quite a while to put together. Now, we do actually have the option of sending it through a transaction desk into Authentisign and having them electronically fill it out. If you need help figuring out how to do that, I'm happy to share that information with you. And I believe it's also in a video on the madronagroup.com under the Forms Agent Bootcamp. So every asterisk, like I said, must be explained if it is yes. Every question must be answered, even if NA or they don't know. So when I go through and I check these Form 17s that are put into our listing files, the first thing I check for is that every box is in fact checked or filled out. Every question is answered. Second, I go through and I look at the asterisks, and we should be doing this with each of our own listings as well. Before it goes into our firm file, we should make sure that it is actually complete, because we're representing that seller. And how are we representing a seller when we are giving that buyer a loophole to get out before the contract even comes together? For this environmental section, nobody is actually exempt if any of these answers are yes. So this is one part of the form that if any of these answers are yes, you have to fill out. Now, if they're exempt in other ways, cross off the rest of the form except this one section, and you can go ahead and fill that out. Do not fill out any other section if they are truly exempt. So knowing your forms, we have 3 different types of disclosures. The regular Form 17 improved is for residential property. The Form 17C unimproved is for vacant land, and 17C is for commercial property. If you're confused about which Form 17 to use, please ask, because it's very important that we send the correct disclosure form. Otherwise, we have not properly given a disclosure. So when you're looking at them, they're labeled in the upper left-hand corner, and I just brought a couple of them up here. Now, they essentially say the same thing in the beginning. They state the law, they state the seller obligation, and nothing changes for that first purpose of this form. It's only going to change in the questions that are being asked. So I just pulled up the first pages on these, and here's a 17 commercial. Now, let's talk about what it means when a buyer waives or does not waive this Form 17. So at the very, I guess, what page is this? One of the final pages. Is this page 6? I'm sorry, I don't have the pages in front of me. At the end of the Form 17, the buyer has 3 choices they can make. The first box right here for paragraph 1 acknowledges the first paragraph here acknowledges receiving this Form 17. It tells that buyer that they do have a 3-day right of rescission to any of the information they learn from this Form 17. The buyer will sign it and date it. It also makes everybody aware that if the house was built prior to 1978, we do also need to have lead-based paint conversations. Now, if they sign box 1, they retain their 3-day right to terminate. They get the chance to look over everything here. And after that 3 days, the right to terminate goes away. And this is all on the premise that they have received a complete copy. So none of the boxes are blank and all the asterisks are explained. Now, if they sign box 2, what they're doing is waiving the right to terminate based on the disclosure they've received. And it doesn't matter if every box is checked or every asterisk is explained. If they sign box 2, they don't retain the right to terminate because of the Form 17. Box 3 is when they waive the right to receive any data in this disclosure, and they waive the right to terminate based on the Form 17. Again, environmental is not exempt because there are things in there that have to be disclosed no matter who is or is not filling it out. So nobody can actually waive receiving environmental, but they can waive receiving the right to look at an entire filled out form. An example of number 2 would basically be a seller who missed a few boxes, but checked off everything in general and delivered this to the buyer. Box number 3 might be for somebody like an estate. If you fill out something in the environmental section that you have to show. Now, if you fill out nothing in the environmental section, no Form 17 needs to be attached to anything. If you are in a situation where the seller is refusing for some reason to sign a seller disclosure form, box 3 would also be an appropriate place to have the buyer sign if you want to make sure that they don't retain that right to terminate based on never receiving anything to begin with. So no matter what the situation, if the buyer waives the right to terminate, then they are not granted the right to have a correction. It will not make a difference if the disclosure was delivered incorrectly or incompletely. So keep that in mind. If you are intending to ask for a correction on the Form 17, or you want an answer or explanation to anything, then do not let your buyer waive the right to receive that. Okay, so let's talk about some odd situations. I wasn't going to go through and talk line by line on what to fill out for the Form 17 because, like I said, it's a very tedious and long form. It's a pretty simple question and answer, and they can just answer as honestly as possible. If they don't know an explanation or an answer, they can just say they don't know. But let's talk about some odd situations that come up that we as agents deal with, not necessarily how that seller should deal with this form. So we'll talk about these 3 first. One is, how do we compute time if a buyer signs and acknowledges the form before mutual acceptance? We know that they have that 3-day right of rescission. What if it's delivered but not acknowledged until the following day? When does that 3 days start? And if a buyer delivers an inspection report to the seller with new findings, does that seller have to update the form and re-deliver it to start over that 3-day clock? Well, in our computation of time discussions, all timelines are computed basically from mutual acceptance. We don't start the counter anytime before mutual acceptance. So if something is acknowledged before it's mutually accepted, that 3-day timeline starts the day the contract becomes mutual. You cannot argue the date of mutual acceptance. Well, what about a buyer receiving it before, but not acknowledging it till the following day? This is where I want to go back to last week and talk about delivery, because delivery is the key. So if they get the Form 17 on Thursday and sign it very, very late Thursday night, and then it's sent back over to the other agent on Friday, or the buyer gets it on Wednesday, doesn't sign it and date it till Thursday or Friday, and then sends it over. Our date for computation of time is going to start the day the Form 17 was delivered to the other agent, not the date it was signed. So get this over to the other agent and CC the TC so that timeline can be documented, because no matter what the date says on the signature line, we are going to go off of the date it was delivered. So brokers, it's your responsibility. That 3-day starts from the date of delivery to the broker and their firms. If you are not sending things over and including your transaction coordinator, they don't know when those dates start. So for communication purposes, if nothing else, make sure that we are keeping those dates very, very clear. Well, what about new findings? Do we have to start over this 3-day clock? Well, as long as the seller has delivered a disclosure that's accurate at the time of delivery to the best of their knowledge, then nothing needs to be updated in the Form 17 for this buyer. That buyer can discover all the new things they want, but that seller was truly delivering what they thought was true and accurate at the time they delivered it to the buyer. However, if the buyer backs out, the information that they've learned, that seller has learned from the buyer, if any, like this would be an example of sending an inspection report over, then it does need to be disclosed for the next buyer or remedied to avoid disclosing it. So let's talk about the inspections. What happens when an inspection is done on a home, if somebody purchases it, and now that buyer is turning around and selling the house? Does the buyer have to fill out what was previously on that inspection report if they're the new seller? And what happens if the buyer has repaired items on that inspection? Or what happens if the seller's in the process of fixing something? Do they have to disclose what they are in process of fixing? And what happens if they deliver maybe an incorrect version of the Form 17, like they deliver a vacant land Form 17 instead of a residential Form 17? Well, if a buyer had an inspection done, bought the house and is now selling, and the buyer did not fix anything called out by the previous inspection, this means that they may still have knowledge of it and it might need to be disclosed. These are all hypothetical. So if a seller is asking you what they do or don't need to disclose, we need to be very careful as agents responding in this way. Just go back to the idea that just disclose anything you know about this home. And if you don't know, just write, you don't know. Now, if the items were actually repaired, then there's no need to disclose, because what we're talking about is the problems that are happening currently at the time the disclosure is given. So if a tree fell through the roof, the day they bought the house, the tree fell through the roof, but then they came by and they fixed the roof, there's no need to say that a tree had fallen through the roof and they fixed it. As long as they have fixed it, and they believe that there is no further issue on that repair, they do not need to disclose it. If the repair was complete by the time of delivery, there's no need to state that it was an issue. And on the same note, there was no need to say that anything else was fixed at all. So an example for me personally was I bought a house, had a lot of problems. My house caught on fire, and in the process of repairing the fire damage, repaired everything on the previous inspection. So I didn't actually have to say anything about my house being damaged, being repaired, because at the time I sold my house the second time, there were no current problems and everything was up to code. Now, what would you do in some of these situations? Just think about these things for a minute. A listing broker receives a full inspection report from a buyer. Then the buyer realizes it was a mistake and asks the listing broker to delete it and not deliver it to the seller. Can this listing broker comply with this? And are there any consequences other than a waived inspection contingency that the seller must be made aware of? Well, we're talking about the Form 17, so there's a pretty good chance that this answer is going to include something about the Form 17. And the answer is a broker cannot undeliver this. They cannot unsee it. You cannot unring this bell. So sorry, now the seller knows everything that's in here. And the reason I'm bringing this up is because this will have a direct effect on a Form 17 disclosure should this buyer not follow through, and now the seller knows about things that need to be put on there. So there is a requirement to disclose material facts, but we need to kind of take a step back and think to ourselves, what is a material fact? So if you think about things that are not necessarily material fact, that of course the public will always want to know. They're going to want to know if somebody died in a house or if something really bad happened in this house. The fact or suspicion that a property or any neighborhood is or was a site of murder, suicide, some other terrible crime, illegal activity, gang violence, political or religious activity, or any other unusual act, or any use not adversely affecting the physical condition of the property is not a material fact. We can't say because the previous owners here decided they were going to have, you know, get-togethers. I don't know. They were going to be creating their own cult in their basement. That is not a material fact affecting the property itself. It does not need to be disclosed. And here are some final thoughts to ponder on this. So what are some consequences of delivering a seller disclosure when they are not legally obligated? This would be the example of an estate sale. You have an exempt party, and that exempt party is only exempt from delivering the actual disclosure. They are not technically off the hook if they have known material information on this house. For instance, if it's an estate sale and they know the foundation is cracked, they need to be disclosing it in some manner. In most cases, someone dealing with an estate sale is truly going to have no knowledge of what the house condition is. So how can they do this in a way to protect themselves with the law as well as create transparency when disclosing something? Well, instead of delivering a Form 17, we are not going to do that. And why? Because delivering that disclosure automatically gives that buyer a 3-day right of rescission. That rescission would not be something that was allowed if this property was exempt. However, if we want to disclose something about the property, we can create a Word document and we can attach it to the listing. We can just simply put it in an email or some other provable way to say, hey, by the way, this is something the seller knows about the house. Here you go. That does not create any sort of contingency out for the buyer. It simply just says the seller's aware of this one thing. All right, so in conclusion to this, a buyer really does need to evaluate each of the disclosed items, especially the ones that are not disclosed. The I don't knows, they may be able to find things that are easily discovered during a walkthrough or home inspection. So have them pay close attention to that as well. Now, if there's many items that are not identified or the I don't knows, a buyer might want to be a little bit concerned about that because not only are they maybe unseen issues, but do you know how transparent that seller is being, or do they truly just not know? A savvy buyer is going to investigate the home with limited disclosure more thoroughly than one that is not as transparent with the truth. I appreciate the time that you've taken to log into my class today. And if you'd like to discuss anything about Form 17 or any disclosures, now is a great time to do so.